During your pretrial deposition, you answer no to a particular question. And now 2 months later, you're thinking about it because you're reading the transcript of your testimony and you realize your answer should have been yes. Is that going to destroy your case? Is that going to destroy your testimony? Will you have the ability to make a change? Would you like to know the answer? Come join me for a walk along the beach as I share with you the answers to those questions. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, what's all this about? I'll tell you what it's about. You decided to bring a lawsuit against your careless doctor, claiming that he caused you significant harm and injury. And now, during the course of your lawsuit, the lawyer who represents the doctor whom you have sued will have an opportunity to question you in a pretrial process known as a deposition. This is a question and answer session that takes place under oath, and in pre-COVID times would take place in our office. Now, most of the time, it takes place on a Zoom video call. The doctor's attorney is on the call, I am on the call, the court stenographer is on the call, and now you are asked hundreds and hundreds of questions that could last in the entire day. One of the questions that you are asked is a very simple, straightforward question. Mr. Jones, have you ever been convicted of a crime? And your immediate knee-jerk reaction, you say, no, I haven't. And now the attorney moves on because you have given him a no answer. Now, about a month or two after you have completed your pretrial questioning, the lawyer who represents the doctor will receive from the court stenographer a transcript because she or he has to transcribe all the questions and all the answers that were given into a written format, and they're put into a booklet that we call a transcript. Now, the defense lawyer then sends me a copy of your transcript. I then have to send it to you to review, make sure it's accurate, with instructions. And I say, if you find that there are typographical errors, if you find that an answer is incorrect, maybe it was transcribed incorrectly, or maybe you thought something different at the time you gave your answer, but now you know that the real answer is different, then you can make changes on a separate page on something called a correction page. And you are to list the page number, the line number, and give the correction of whatever it was that you believe needs to be corrected. You are then to sign the correction page, you sign the transcript, and you send it all back to us. Now, once we have that, we make copies of that, and then I am obligated to return that back to the defense lawyer. Now, why is that important? Well, in this example, you answered no when you were asked whether or not you had ever been convicted of a crime. And the more you thought about it, the more you realize you should have answered yes. And now, when you get this transcript back, you realize that the answer is no, and you should put the answer is yes. So you call me up and you say, hey, can I go ahead and correct this? And the answer is yes, you can. But then you and I will have a discussion about what it was you were convicted of. And why was it that you said no at the time you were asked this question? Now, why is this such a big deal? I'll tell you why. It's a big deal because when you said no, the defense attorney stopped right there and didn't ask any more questions about that. If you had said yes, the attorney would be entitled to ask a few more follow-up questions about that particular conviction. Now, you should know, most of the time these defense lawyers will do background checks on you, on the injured patient, on the injured victim. And if they find that you were convicted of a crime, and now your case goes all the way to trial, now they have a clear contradiction between what you testified to and what the real truth was, meaning that you were in fact convicted of a particular crime. And the fact that you lied about it is now going to be a central theme by the defense attorney to show to the jury that you are not credible, that you are not believable. So if you fail to make that correction in your deposition testimony, you are going to create a huge, huge problem for yourself. Why? Because that contradiction is going to come back to bite you in the butt, guaranteed. Guaranteed. And they're going to do it in the form of an ambush at trial. They're not going to give you warning about it. They're not going to give us notice about it. They don't have to do that. They're going to spring it on you. At trial, the defense attorney is going to go ahead and show to the jury that you are a liar. And they're going to do it in a very easy way. How? They're going to get you to answer questions similar to what they asked you during your deposition. Mr. Jones, have you ever been convicted of a crime? No, absolutely not. Okay. And your name is John Jones? Yes. And your middle initial is A, is that correct? Yes. And that's been your name since you were born, isn't that true? Yes. That's on your birth certificate, right? Yes. That's on your passport, correct? Yes. That's on your New York State driver's license, is that correct? Yes. And you've never been known by any other names, is that right? Yes. And your date of birth is as follows, isn't that right? Yes. And your social security number is as follows, is that right? Yes. And now they're going to go through where you have lived for a number of years. Now, you've lived at this particular address for X number of years, is that right? Yes. And before that, you lived at this address, yes. And did you live there continuously? Yes. And did you live there continuously until you then moved to this other location? Yes. At some point, the defense attorney is going to offer into evidence a document for the judge to look at. He's going to ask the court to take judicial notice that this particular document from the Department of Corrections of the state of New York confirms that you, John A. Jones, with the following address, with the following identifying information, were in fact convicted of the following crime at this particular date. And in addition to being convicted of that crime after a jury trial, you then served a sentence of 5 years at this following facility, and you were incarcerated. And now the court will take judicial notice, meaning that he will acknowledge that this is a certified copy of a document confirming all of these facts. Now, what's the purpose of this? The purpose is to show that you, my friend, are being less than truthful, to show that you, in fact, have lied. And now your credibility is severely in doubt. And the defense is going to make a very simple argument to the jury at the end of your case. You're going to turn around and say, ladies and gentlemen, I don't know what the big deal is. All that Mr. Jones had to do was simply acknowledge and admit that he had been convicted of a crime that has nothing whatsoever to do with the claims being made in this case. But he's not credible. Why? Because he lied to you. He lied when I asked him the question during his deposition, during his pretrial deposition, a year before this case came up for trial. He lied to you, to your faces, when he said that no, he was never convicted of a crime. He lied to you. And if you can't believe him about one little thing that has no bearing whatsoever on the facts and the details of this case and the claims in this case, how can you believe anything he had to say concerning the real issues in this case? So, let's go back to the question I raised in the beginning of this video. Will it make a difference if you go ahead and fail to make those changes? Yes, it could significantly affect you and your case if, in fact, that answer that you initially said no to, that the real answer, the truthful answer, was yes. And if you failed to correct that during the time that you were being questioned by the opposing lawyer during your deposition, that could be a problem. And if you failed to correct that problem during the course of time that you are reviewing your transcript, that's going to be an even bigger problem. Can you try and explain away why you gave that answer during the course of your trial? The answer is, of course you can try and explain it away, but by then, it's going to be too late. You've already dug the hole, and now you've stepped into it. So why do I share this quick information with you? I share it with you just to help you understand how these types of cases work in New York. You know, I recognize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.